welcome to today's session of Africa in the Moot's Education and Training Series. My name is Loredana Eisner, and I'm a member of the Education and Training Committee of Africa in the Moot. I will co-moderate today's session together with my colleague Benjamin. Benjamin, would you like to introduce yourself to our participants?
Of course. Thank you, Loredana, for the introduction. Hi, everyone. My name is Benjamin Ngeno. I am a director at Africa in the Moot, and I also am an associate. I live in London with the arbitration team. So it is a delight to be here today and looking forward to the discussion.
Thank you, Benjamin. Well, as many of you know, Africa in the Moot is a volunteer-based organization committed to provide training, mentorship, and opportunities for students across sub-Saharan Africa and beyond. And today's session is about the CISG, in particular with a focus on damages and calculating damages. And for this topic, we do have two experts on this field, which we want to welcome, who are Professor Peter Huber and Professor Loukas Mistelis. Neither of them probably need an introduction. However, I'm going to do it anyways. Starting with Professor Huber. He is a professor of law at the Johannes Gutenberg University in Mainz, Germany, where he has held the chair for private law, conflict of laws, and comparative laws since the year 2000. He also held visiting professorships at several universities, including universities in the United States, France, and Japan. Peter Huber has been the coach and a patron of the University of Mainz's Vis Moot team since 2003 and has acted as an arbitrator in Vienna ever since. In 2018, he has even arbitrated the grand final in Vienna. So I would say there is a great chance that you might meet Professor Huber in Vienna in 2026. 2026. There you go. One of his key areas of expertise is international sales law, international litigation, and international arbitration. Welcome, Professor Huber. And then our second panelist today is Professor Loukas Mistelis. Professor Mistelis is a professor of transnational commercial law and arbitration at Queen Mary University in London. And he's also a partner at Clyde & Co. in the London office, where he focuses on international arbitration. His research focuses, among other things, on international arbitration and international commercial transactions, for which he is internationally recognized. Professor Mistelis has practiced law in different jurisdictions, which are Germany, Greece, and the UK. And in addition, Professor Mistelis frequently sits as arbitrator. Welcome, Professor Mistelis. So before we begin and I hand over to our two panelists, I want to highlight what we have planned today. We will start with a short presentation of our two panelists, and then the main part of the session will then be an open conversation. Your opportunity to ask questions, engage directly, and make the most of having two brilliant experts with us today. We strongly encourage all of you to actively participate. This is not just a lecture, it is meant to be a discussion. So ask questions, share your perspective, and engage with the subject matter. At the end of the session then, my co-moderator Benjamin will share additional remarks and bring us to a close. So with that said, I hand over to you, Professor Huber. I think you will start.
Perhaps it would be fair to say that Peter Huber prepared the presentation we're going to see. That's good to take it from the beginning, and I will be acting largely as a commentator. Sometimes we will agree, sometimes we will disagree, but it will all be flowing naturally rather than being staged.
Well, that will support the discussion.
Thank you very much. Yeah, thank you everybody for having invited me here. It's a great pleasure, huge honor, and I was really looking forward to this. And as Loukas has pointed out, we had discussed it previously, and we thought we would just give you one sort of presentation with a short overview over topics that we think might be relevant in this year's Moot. And the idea was that I do the preliminary talking. I'll take you through the slides, and whenever Loukas thinks that I'm getting something wrong or that a different opinion would be more suitable, he will just jump in, or if he has something that he has experienced, whatever. So that's the idea, and we hope it's a bit more lively as if everybody gives his separate presentation. And we're also looking forward, obviously, to the question session afterwards. Now, I am still, here we go. So, right. What I'd like to do, or what we'd like to do is, we would like to start with some very few general points, then have a small chapter on breach of contract and system of remedies in the CISG, and then the final chapter on really damages calculation, which obviously is one of the core issues of this year's Moot. Primarily, we will be focusing on topics that will be relevant in issue 4. Now, for the general points at the beginning, you may have heard them in the introductory session, but there are a few points in my 20 or more than 20 years experience with Moot, at least, always come up, and it's just quite good to know them, basically. And they have to do more or less with interpretation. The first point is interpretation of the contract or of the declarations of the parties. Now, we've got a provision there in the CISG, Article 8. It distinguishes in 8.1 and 8.2 between two different scenarios. That's not a story we'd like to follow on today. More or less, it's the understanding of a reasonable person, broadly speaking. The one point I wanted to make here is this provision in Article 8, paragraph 3, which more or less says that in interpreting the contract or the declarations of a party, all relevant circumstances should be taken into account, including, amongst other things, the negotiations between the parties and the subsequent conduct. So I think it is simply valuable to remember that this provision is there so that the starting point obviously would be, if we take the point of negotiations first, that under the CISG, in interpreting the contract, you can look to the negotiations, which is not self-evident for people coming from the common law, for common law systems, parallel evidence rule, etc. Of course, with different variations in different legal systems. But the starting point in the CISG is that you can look to the negotiations. In other terms, that there is no parallel evidence rule or such. Unless, of course, there is a merger clause in the contract, and then it will depend on what the merger clause precisely says, means, or wishes to exclude, and that will leave room for argument. But I think that this plays a role in some of the issues of the Moot problem this year, so I just wanted to highlight it. The second part is subsequent conduct can be taken into account. And maybe a word here, obviously, this cannot mean that after you've concluded a contract, one party can simply change its mind. That's not what it means. But what it means is you can look at how this party behaved during the performance of the contract after the conclusion, and then you can try to derive from that an idea of what this party probably must have meant when it was agreeing to the contract. So, for instance, if one party claims that it was them, or it was they, who had the right to determine the exact amount of goods to be delivered, plus minus 10%, whatever, one might look to whether, when it came to it, they actually did make that determination. Because if they didn't, maybe then their later claim that actually it was them who were supposed to choose is not so convincing. So maybe it's just a statement that they make up now. I'm not saying that's the case in the file, but it can help maybe having a look at the subsequent conduct, and it is possible under the CISG, and that was the purpose of this slide, actually. And just one other general point is now interpretation again, but of the convention itself, of the text of the statute, as it were. And it's only the second part here that I wanted to highlight. It's this internal gap-filling mechanism. So if you are within the CISG, which we usually are when dealing with the moot court. And if you don't find an article that really solves your issue or solves your problem, then we have to fill this gap. It's an internal gap because we are within the CISG, but we don't find a provision. Probably in the national legal systems, one would think of things like an analogy to another provision. The CISG frames it a bit differently. It says, first, please look to whether you can find general principles on which the CISG is based. You can probably derive those principles then from other articles of the convention and say, well, that's similar, so maybe let's do it here as well. And only if that's not possible, go to the applicable domestic law. It's just a mechanism that probably one will need at some point or another, and if only to make up in the memo a rule that one needs, and then just sell it as a general principle. But then it's always good to refer to Article 7.2. That's why I mentioned these two provisions, although they were strictly speaking not part of today's topics.
So two very brief comments, if I may. If you look at the CISG scholarship, you will see that there are, largely speaking, two groups of scholars. Those who want to accommodate under the umbrella of the CISG almost everything, effectively, so that they will focus very much on this general principles on which the CISG is based, rather than refer to conflict of laws and sort of applicable domestic law. And those other scholars who take the view that actually the CISG doesn't even harmonize the entire sales contract law, but only aspects of it, and therefore you need to do that. Depending on which argument you want to present in your memorials, I think you will find support from both theories. One is an expansionist view, which one is a bit more narrow, and I think when it comes to 8, perhaps one thing that needs to be said is also that we take view that 8.3 is omnipresent, but you either choose 8.1 and 8.3 or 8.2 and 8.3. So you don't normally use 8.1 and 8.2 and 8.3. Use either 1, subparagraph 1, subparagraph 2, subparagraph 3. And given that a contract is relevant and communications are relevant, that would be sort of coming into play as well. And I think it's appropriate that Professor Huber has included these two key provisions in the picture.
Thank you. Exactly. I completely agree. Yeah. So now for the second part, which actually will address now breach of contract and system of remedies, we just thought a small overview might be quite helpful just to bring us back onto the scene, as it were. So now, if you look at the system of remedies in the CISG, you will realize that the structure is that it first deals with seller's obligations and buyer's remedies, and then the next chapter is buyer's obligation and seller's remedies. And in the end, the system of remedies usually they look very much alike. So you have it twice for the buyer and for the seller, but they are very similar. Now, this would be sort of an overview, if you'd like to see, for seller's obligation and buyer's remedies, which is obviously not probably so much the issue in this year's moot. We included the slide more or less to show you that it's a similar system. And what they both do is, and that's that's the part highlighted in green, that for a claim for damages, they will refer you to the general rules on damages, which is Article 74 and the following provisions, which are sort of outside this bracket, which are common rules for both sellers and buyers' claims. With that, I'd rather like to go to the next slide, which is actually now probably the part that we need. So in the left column, you find the obligations of the buyer, and probably the obligation which plays the most important role in this year's problem is the obligation to take delivery, because obviously the buyer didn't take delivery here. So it would be Article 60 or Article 53 and 60, which would probably amount to the breach. And in terms of remedies, you see again, it's the same game, as it were. So usually the remedial section starts with an outline provision, that's Article 61 here, which gives you a catalogue of the potential remedies that the seller, in our case, might have. And there would be a performance claim. It might be the right to avoid the contract under Article 64. And then there is a damage claim again, which again refers to the general damages provisions in Article 74. The other two points I mentioned are specific issues which, well, probably will not become so directly relevant. I'll try to be a bit vague on that, but which probably will not be so relevant. I think the topics we have to look at this year is obviously the damages claim. That's number one. And under the heading of the damages claim, also a bit the avoidance issue. Was there a question or was no? Sorry, okay, so we can just go on. So if you look at this system of remedies, there are a few striking points. Not all of them will necessarily be relevant this year, but I think it's always good to have them in the background. Now, as for damages, it's a system of strict liability, meaning you don't need fault. So you don't need negligence to be liable in damage, to be liable for damages, which is markedly different at any rate to the system I come from in Germany, or to many other civil law systems. It is probably more similar to the common law system. So you have a non-fault-based damage claim, which simply appears from the fact that fault is not mentioned in the damages provisions. However, as is usually the case, if you have a strict liability system, there must be some limitations. And the most important limitations, and that's the but on the slide, are the exemptions that are provided in Articles 79 and 80. And obviously now Article 79 is the cornerstone of issue 3 of the Moot problem, which we are not going to deal with today. But that's, of course, one of the arenas where the game will be played. A final point I wanted to mention is the so-called contemplation rule or the foreseeability rule. In the general damages provision, which is Article 74, it says, I'm paraphrasing now, well, all types of damage can be recovered if this type of damage has been foreseeable to the debtor as a possible consequence of the breach. So that's the famous foreseeability rule, which comes more or less probably from the common law legal systems, which will be applicable to the general damages claims. I mean, maybe we can have a talk later on what is and what is not foreseeable, but that would just be sort of the structure. A final remark in that context on the system of remedies deals with avoidance. Avoidance is treated as the ultima ratio, as a remedy of the last resort in the CISG. So the idea is that before the creditor, in our case, the seller, would proceed to avoid the contract, the convention would try to check whether maybe other remedies are available that would also see him right, as it were, that would also sort of help him cover his losses, etc. Particularly a damages claim, but it might also be a performance claim or a related claim, etc. And that is why typically, this ultima ratio principle is why typically avoidance will require a fundamental breach. Of course, there are a few exceptions. You may have the famous Nachfrist procedure, which still has a German name tag to it, but the fundamental breach requirement is probably the most important rule, and that, of course, may play a role in the Moot case as well. Although, obviously, if one party really finally refuses to make its own performance, then this will, in all probability, amount to a fundamental breach. So these were two general points on the system of remedies that I wanted to highlight here. And now we could go on to the actual issue of the calculation of damages, which is obviously now at the heart of issue 3 at any rate. I'm not sure whether you can read the slide now, because on my screen it's rather small, but that may be due to my screen and my inability to make it larger. But this is basically an overview over the relevant provisions. So if we assume that the breach of the contract was the breach of the obligation to take delivery under Article 53 and 60, which were the first two provisions, then the sellers here, the claimant's remedies, would result from Article 61. And as they claim damages, it would be Article 61, letter B, which gives him or can give him a claim for damages under the further requirements of Article 74 to 77. I made a short note here that, of course, you will also have to see whether there's an exemption, but that would be then issue 3. For us, the most relevant part for us is actually Article 75, because because the question or issue 3 as it stands at the moment only asks for damages calculation under Article 75. And the provision reads, if the contract is avoided and if, and now comes the yellow part, in a reasonable manner and within, again, yellow, reasonable time after avoidance, the buyer has bought goods in replacement, that's not our case, or the seller has resold the goods, the party claiming damages may recover the difference between the contract price and the price of the substitute transaction, plus any further damages under Article 74. So that is the central rule for issue 3 for the damages calculation in this year's moot problem. If we try to compare this rule with the general rule, that would be done on the next slide. So if you start with the right, the red one, so the right column with the red arrows, that would be the damages claim we are talking about. And that would be the requirements that would have to be given. So first, there must have been a breach of contract by the buyer. Second and third, no exemptions, not our topic today. And then there are some specific requirements of Article 75 that need to be met. If we paraphrase them broadly, there must be an avoidance and there must have been a reasonable cover sale. Then we also have to look for whether there was maybe a mitigation issue. And if Article 75 is given, then we have a specific way of calculating damages. So that's the idea about Article 75. If you compare that with the general damages provision, which is Article 74, which is the left column, you can see that actually the requirements are almost the same, except for the, well, I don't know what color that is, the greenish sort of point, which is the foreseeability or the contemplation rule that we've mentioned earlier. So if you look at the difference between 74 and 75, the difference is that for 75, at least if you look at the wording of the provision, you do not need the foreseeability of the damage. Now, I know, and whatever Loukas and I say today, you will always find someone somewhere who has a different opinion. That's part of the game, I guess. But I think the predominant opinion and the wording of the provision is clear that the foreseeability rule, you would not need this requirement if you go on the right side under Article 75. So that's one of the differences between the two provisions. And the second difference is that Article 75 gives you a specific way of calculating damages that may not necessarily be possible under 74. It may also be possible, so that's a bit of a vague comparison. But that is the system. So you don't need the foreseeability under 75 if you follow the predominant opinion, and then they give you a specific way of calculating damages.
If I may make a couple of comments here, it's interesting how do we see the sort of the structure of the CISG and effectively remedies. I think, sorry, I'm one of these rooms which you have to move, otherwise the light goes off. Just give me a second.
Ooh.
So that's the first thing, and of course we also see that the intention of the legislator is to use the damages as the reasonably to be done process after methods have been exhausted in which the parties stay in the contract and perform the contract where they can. Where I've always found the difficulty between sort of the references from the breach provisions and the Article 74, 75 to me, of course, Article 74 has the clarity. It gave us full compensation. Then, of course, we start having a sort of checks and balances, reasonableness, foreseeability, and all of that. And arguably, 75 operates only if the conduct has been formally avoided. So there's a bit of a limbo there, if you wish, from trying to perform, or a party refused to perform, to formal avoidance. And the question is whether 75 only operates once we have a formal avoidance or not. That's one of sort of the techniques that the legislator has adopted at the time, which could have been a bit more fine-tuned. And I wouldn't be surprised if this comes up as arguments in Vienna, because that's one of the things that you can hinge on to make a slightly different presentation. But 75 for sure gives you a method of calculation, which in most cases would work reasonably well to get where you need to get. And of course, the foreseeability would then go into the question as to how far can you go into recovery and what types of recovery you can get.
Yeah, thank you very much. This thing with performance avoidance or not, that will, I think, will occupy us a few times more even now today. Now, if we go for 75 and have a look at the requirements, so the ones which are in yellow actually are the specific requirements that Article 75 would set up. So that's just the collection, avoidance of the contract, and the seller must have resold the goods, cover sale. This must have been done in a reasonable manner and within a reasonable time after avoidance. And at the end, we still have this sort of this sword hanging above our head, which is the mitigation issue. If we go a bit on into the details of it, so first requirement, the contract must have been avoided. I think most people agree that it has to be a justified avoidance, so it must be an avoidance with reason. You must have a basis for this avoidance. In our case, it might be Article 64, possibly also Article 72. That is probably where the discussion is heading. I think, if I remember the file correctly, I mean, they declared an avoidance and nobody really disputes in the end that there was an avoidance. And the discussion rather is, was the cover sale too early, or was it much too early, maybe only slightly too early? So that would be the next topic. But that refers to what Loukas was saying. Obviously, the idea that you calculate damage on the basis of a cover sale will have necessarily presuppose that there must at some point be an avoidance, because otherwise you buy the thing twice if you are the buyer, or you sell it twice if you are the seller. So that is all very intertwined. For the cover sale, so that's the second requirement. The seller must have resold the goods. We call it a cover sale, or I think the statute, the convention calls it a substitute transaction, but in our case, it would be a cover sale. Now, the question is, what does make another sale a cover sale? We're not yet talking about the timing. The question is, when is it a cover sale? Well, I think most authors, people would agree to say, well, it must be suited at least to satisfy the seller's performance interest, or his fulfillment interest, or expectation interest, whichever term you may use. Probably, I mean, if first I sell to the respondent and then I sell to herbal cosmetics and it's the same type of goods, then I think probably here we do not run into too much difficulties in terms of, was it able to be a cover sale? Probably, I would assume. There are a few issues where I'm not really sure yet whether they will play a role or not. What if the seller sells these type of goods regularly? How can he then point one of his regular transactions as being the cover sale? Does he have to give notice, or do we simply take the first sale that is concluded after avoidance? I made a few dots because all sorts of things are discussed here. I just wanted to raise the issue. And then obviously the big question, what if under the original question, a sales contract, the quantity was not precisely determined, plus minus 10%? I mean, what do we do then? I mean, maybe in the discussion that will come up. I just wanted to raise the question here for the moment. Then comes probably, sorry, exactly. Then probably comes one of the points which really are a big issue this year. Article 75 clearly says that the cover sale must have been concluded after the avoidance, which probably we all agree wasn't the case here, because the avoidance came after the cover sale. But, and that's probably the discussion, there is a huge debate about whether there are exceptions to this rule. And most people would say, yes, there are. And the most prominent exception is if the debtor, in our case, the buyer, has finally refused to perform. Seriously and definitely refused to perform, whichever terms you want to use. Yes, and that will, of course, then be an issue here. Well, did they already, or did they finally refuse to perform? When did they do it? When did the cover sale occur? So I think that is one of the big issues. Related to that, it must be done within a reasonable time. But that, of course, presupposes that you know when sort of the refusal actually took place, and then you can calculate a reasonable time. But in this year's Moot problem, it all seems to have been done pretty quickly. I mean, the problem here is rather they were too quick and too fast than they were too slow. In a reasonable manner, it says in Article 75, well, I mean, it relates to price and terms of the contract, and the question is again the standard. Now, the typical standard is the careful and prudent businessman, whatever term you might use, but that's probably not too helpful as a standard yet. Some elements that might become relevant is, well, how much do we actually require the seller to make in terms of market analysis? Can he take the first offer? How many should he ask? How much? Another element is it urgent? I mean, and in the Moot, we are talking about products where time can be an issue. So I think they lose 30% after their first flowering. These flowers, etc., they have to be planted until a certain time. So maybe there's a certain element of urgency, and the more urgent it was, the less strict can we be on the seller when it comes to the reasonableness requirement. And then finally, again, the mitigation requirements. I mean, of course, you could have said, well, you could have waited until you get a better price. But then you also have the reverse situation. What if he had waited and not found somebody else with a better price and lost the first offer raw? Then there might be a mitigation discussion. And then the other party might say, well, yeah, but you should have sold to the first party. And that, I think, makes it difficult for the creditor, in our term the seller. And I think because it's so difficult, one should be rather generous as long as he doesn't do anything unreasonable. But that's my personal opinion. I'm not sure whether it's sort of predominant in a way. Yes, then I think we've touched on that. Do we still need a foreseeability rule under 75? The wording is pretty clear. It doesn't, because it doesn't mention the foreseeability rule. As I said, it's a bit disputed. But probably in the end, if I'm not taking as a buyer delivery of the goods from the seller, is it foreseeable that a commercial seller will then sell it to somebody else? Well, the answer will probably be yes, I guess. So that's probably not so difficult here. And the consequence would be that the damages are calculated on the basis of the price in the covered transaction. So you compare the contract price, the original contract price, and the price of the cover sale, but not Article 75 does not give you the market price. And if I understand it correctly, if you take the price of the cover sale, that is better for the claimant in our case than if we were to take the market price. So that, I think, is the interest behind the discussion and the issue. In addition, 75 says seller could claim any further damages under the rule of 74, including foreseeability, costs associated with the cover sale, but I'm not sure whether that actually does play a role in this year's problem. What if 75 does not apply? I mean, that's the background story. And now again, we come to Loukas' sort of remark on integrating it into the entire system. I mean, if we say it wasn't a cover sale, or if we say it wasn't reasonable, what can the seller then do? Well, first, they could go under Article 76, because that applies if there was no cover sale. But that would give them the market price. which probably is not what they want, because it's lower. I mean, because it's worse for them, the method of calculation in this case. Probably they could also go under Article 74 and prove their damage under 74, with the argument that, well, actually, we had to do this cover sale because that was a mitigation measure. And if it was a mitigation measure that is expected of us, then probably we should be allowed to recover the amount as damages. At least that's an argument one could make. The issue I'm having with this is that as it stands now, the question, issue 3, just asks for calculation under 75. So I'm not entirely sure whether this is appropriate to bring it up in the Moot memo or not. Okay, and I think that basically concludes the presentation we wanted to give. We just wanted to say good luck and enjoy the Moot. We hope that it will be as fantastic an experience as it has always been for us. Thank you for listening.
I have 3 comments in relation to this final slide. Of course, I'm pretty sure that many of you would have already encountered one of the CISG Advisory Council opinions, drafted by John Kotanda. That was opinion number 8, which very much look at the calculation of damages under 75 and 76. And I think it's something that you will go back a few times to review, because as you know, the CISG Advisory Council opinions have black letter statements and explanation. Of course, that's an opinion which was drafted back in 2008, if I'm not mistaken. So there's quite a bit of water under the bridge, as they say. But the 2 things that you have to take away is that 75 and 76 are presented as alternative to 74, which means is not, while 74 works on the basis of full compensation, 75 and 76 bring you calculation formulas which might be full compensation, but they are market-driven compensation. Let me put it this generic term. And therefore, if you look also at the black letter, it's suggested that sometimes if 75 doesn't take you where you need to go, or 76, you might also have supplementary damages under 74. That's already complicated enough in real terms. And one of these things is effectively the point that Professor Huber made very, very clearly, so to whether the sale is reasonable. And I think in the fact pattern of this year, that's going to be quite a big discussion, while 76 looks not at the subsidy transaction, but looks at the market sale. So there is some sort of a lot of the CISG provisions do not stand alone. They work is a bit of a web. You need to go back and forth to get where you need to get. And I think not just, I mean, obviously I've been living in a common law environment for the last 20 years. So facts are key in getting where you need to get, but the way the Moody's operate is very much focusing on law and legal principles. So look abstract the text of the convention a few times and back and forth, and within its section in which it belongs, but also how it relates with other sanctions, because that sometimes gives a bit of answers that you would not expect to find otherwise.
Thank you, Professor Huber and Professor Mistelis, for your comments. That's really insightful. And at this stage, I want to emphasize again that we do have a chat box. So if you have any questions for our 2 panelists, please put them into the chat box, and then my colleague Benjamin will read them for us so that we can get an answer. Benjamin, do we have a question already?
Not just yet, but there is an appreciation saying thank you for the wonderful insights on the principle of cover sale. And this from Cavendish University, Uganda. So it's appreciated.
Okay, well, then for the time being, I might ask some questions myself. It goes to the both of you, of course. But Professor Huber, you have mentioned and touched upon this before, and the fact that avoidance is obviously the ultima ratio. So my question would be, can then a party avoid a contract in case of anticipatory breach of contract at all? And if so, which indicators would you consider suggests that prior to due date, a party will likely not perform its contractual obligations. Professor Huber, you're on mute.
All right, that usually happens. Doesn't happen in the lecture theater, that's why. Okay, so yeah, well, I think, yes, I mean, so there's a provision, Article 72, which says that in the case of an anticipatory breach of contract, the creditor may avoid the contract. I think it says something like, if it is clear that the other party will commit a fundamental breach of contract. So that would be Article 72, para 1, I think. So if it's clear that there will be a fundamental breach, but again, we have this fundamental breach requirement, then you can avoid the contract in an anticipatory manner, meaning already before the actual date for delivery or for performance. And arguably, I mean, we said that under 75 or even 76, we need an avoidance of the contract. I mean, and we also said that this avoidance must be justified or must have a legal basis. So I would suggest that obviously 72 could be a legal basis as well for an avoidance. And maybe it is an area of time where we are in a moot case. I've just had a chat with a few of our mooties here this morning, and they are still being a bit vague on it. Whether it's 72 or 64 or on which you rely, but it is definitely a topic worth exploring. But maybe two final remarks on that. First, yes, but it also implies a fundamental breach. So it's the same standard in the end as under the ordinary rule of 64. But then on the other hand, if there was a definite refusal to perform on the side of the respondent, then probably that would amount to a fundamental breach. So that requirement would be given. So to cut the long answer short, yeah, you can avoid for anticipatory breach. It's Article 72. It has a few more paras. It might be worth exploring. And you need the fundamental breach requirement.
Thank you. Maybe we said we would be going to focus on the calculation of damages. So I might have some questions here as well. I
think we have one in the chat.
Yeah, you're right.
Go ahead, please.
Oh, yeah, well then, please go
so
first.
One question to either you, Professor Huber, or Professor Mistelis is, can Article 75 and 76 be relied on concurrently?
That's for you, Loukas, I guess.
Yes, I think in principle, one has to decide whether there's a cover sale or there's no cover sale. If there's a cover sale, then you go to 75. If there's no cover sale, then there's a price mentioned in the contract and there's a market price, then you go to 76. It will feel a bit greedy to be able to throw out all options you have, 75, 76, or 74. And I think if we are not in if we're in an arbitration environment, alternative claims can fly much better than in litigation, where you have to make a choice, and then if you don't meet the first standard, a lot of courts will dismiss your claim. So the fact that we're in arbitration, making alternative cases could work. But I think it's a matter of credibility of the party seeking damages to be able to have clarity as to what they're asking and why they're asking it. And I wonder whether the better concurrency is 75, 74, 76, 74, rather than 75 and then 76, and then possibly 74. But Peter might have a different view.
Probably not. I think, I mean, it's as you say, I mean, if you look at the wording, 75 says, I apply if there was a cover sale, and 76 says, I apply if there was not a cover sale. So probably if you say, because the question asked, I think, can they be relied on concurrently? Now, I'm not a native speaker, but it depends on what concurrently means. So probably, and that's what Loukas always said, if you says, well, first we want 75 plus then we want 76, probably that would not work under the CISG. If you say, well, our first argument is that actually it was a cover sale and it was reasonable and therefore it was 75. But secondly, if the tribunal decides differently on whether it's and thinks it was not a cover sale or it was not reasonable, then probably, I think also, Loukas, you would not have any concerns, probably then, of course, going to 76. So that's probably possible. I haven't checked now today, and in my age, you tend to forget things, but I think actually the question, issue 3, only mentions 75. It doesn't even mention 74, which, as Loukas has indicated, as I feel as well, actually a quite an interesting point would be, what if we are kicked out of 75, but we can exactly the same amount and exactly the same calculation under 74? Because that might be possible to argue, at least. But I'm not sure whether it's actually asked, given the question.
Indeed, it's not asked, but the alternative, an alternative submission, whether it's concurrent or not, would work in an arbitration environment.
Yeah.
Well, thank you for answering these questions. If there are not any more questions from the students, I'm happy to ask more questions. Benjamin, are there any questions in the chat box?
None at the moment, so feel free to ask. Yeah.
So we have, or I think you, Professor Hugo, the both of you have touched upon this before, and I wanted to ask a question, and this is, how should the contractual quantity be identified for the purpose of calculation of damages if the contract provides for flexible or variable quantity? So what elements would you consider in such an assessment?
Nobody's volunteering because that's the most difficult question, I guess. Well, so I'll just start again, and Loukas, you'll jump in if you think it's different. Well, probably. I mean, if the quantity is not precisely determined, it is done so in the contract, and this is the case here. I think it says 3,000 plus or minus 10%. The contract between the respondent and the claimant. So I think the starting point again would be the interpretation of the contract. So you have to look, I mean, if the contract were to say, well, 3,000 flowers or plants plus or minus 10% at the choice of seller or buyer, then it would be clear. But I think if I remember correctly, it doesn't. So then you have to interpret it in a way. And then again comes the issue of, well, what am I allowed to take into account? And our 8.3 would say, well, you are allowed to take into account, on the one hand, negotiation history between the parties, on the other hand, subsequent behavior, unless there is a merger clause in the contract, which then you again would have to interpret what it precisely is supposed to mean. But let's assume we stick with 8.3, and let's assume we do not find a merger clause. Then, I mean, you can look at such things like, well, how did they behave afterwards? I mean, if one party, I mean, I'm always thinking, if the buyer really thinks that it is him or her who should determine the precise amount, then one could ask them, well, did you do it throughout the course of the story? And if you didn't, doesn't that maybe show us that in the end you didn't really think that you were the ones who were allowed to do it? Because if it was your right to determine the exact quantity, at some point probably you would have done it, because I think they determined the delivery date. And I'm not entirely sure now, but if I remember correctly, they did not on that occasion determine the exact quantity. Correct me if I'm wrong, because I think all the students know the file much better than I do at the moment. So maybe that might be an issue to look to the subsequent behavior. Loukas, do you have any ideas from your practical experience?
I haven't studied the program as precisely as other people would have done, but certainly this would be the type of questions I think is worth asking.
Yeah, and exactly. And if you look at, I mean, I've tried a brief look at the commentaries, but they would usually be rather general. They would say things like, well, typically these clauses allocate this right usually to the seller, probably, because then, especially if it's a risky production, you might lose something in the course of the production. So it's for the seller maybe to say minus 10%, or you have more plus 10%. So I found a few statements in commentaries saying, well, typically this is with the seller, but I'm never quite sure whether they actually state this as a legal rule, or whether they just state it. If you look at these clauses, the clauses will usually give this right to the seller. Maybe it's even rather the latter. So I think looking in commentaries, and I saw Loukas shaking his head, probably will not help very much there.
I think there's an element of discretion that one needs to afford to the seller. I think there's also, in terms of the general rules, perhaps that's when it becomes more interesting. A lot of the rules will be is that you cannot use an Article 75 and put a party in a better position than would have sort of had the conduct been normally performed. I think that's the element that comes into the picture. So I think the idea is that the aggrieved party should not be put in a better position than it would have enjoyed if the conduct had been performed as anticipated. And I think that's certainly one of the principles of Article 75 as well.
Yeah. And in the end, as you said, I mean, in the end, it's going to be, again, fact-based things, interpretation, and Article 8.3, if we are stuck with it, would give you the room to find things in the file. And in my experience in the Moot, really very often the discussions then end up in being fact discussions from the file. I mean, obviously you need a lot of legal principles, etc. And then they say, well, but on page so-and-so it says this, and the other side, yes, but on the next page it says the opposite. And probably if one looks to the file for information on what might they possibly have thought that the contract actually says and how did they behave, then one might find points to argue. And quite honestly, I don't really know the answer either at the moment. I'm sort of also just trying my luck.
Professors, we have one question which I think will lead us now into the conclusion, and this is more of guidance. Do you think the question of a pre-avoidance cover seal conflicting with Article 75 is a viable dissertation topic? So as professors, I think you might have something to say to this.
Of pre-avoidance cover sale conflicting with Article 75 is about. Well, I think it's definitely a topic one could write a lot of things about. Loukas, what do you think?
I mean, one reaction is that it's a bit too narrow. I mean, an English dissertation works on the basis of putting forward an argument and trying to verify it. So if you see it as a narrow research question, yes, that can develop, but then you need to have a bit of sort of musings in comparative law to write the amount of things that you need to write. Yes, as a research question is narrow enough and distinct enough and novel enough, but in getting to where you need to bring in quite a bit of a non-CISG content to make it a dissertation length subject.
That's probably true. And maybe one other aspect, because you just mentioned the novelty. I mean, the problem with these problems or discussions is that the CISG dates from 1980. So probably a lot of things have been written on that issue already. And now the question is, does that sort of exclude the possibility of writing a dissertation on it? And it might be a problem, either because there's a lot of materials or either because you don't really find much new to say. So that is, I guess, that might be an issue, but probably that's something one would have to discuss with the professors in place, or whether they are happy to have a narrower topic or want an argument topic. But I think we can both agree on that. At least it's a very interesting question.
Yes, absolutely.
Well, on that note, we have come to the end of this very insightful discussion. We really do thank you, Professors Huber and Mistelis, for having taken time out of your very busy schedules to, one, encourage your students, speak to the problems they'll be facing in the moot problem, and also clarify some of the things that they'll be dealing with. We are. It helps also just to let us know as the viewers why we're doing this, highlight who Africa in the Moot is, and how you can support us as a volunteer-based nonprofit organization. We were founded in 2021, and we support talented African law students to participate in the Willem C. Vis Moot competition. It is known that Sub-Saharan Africa has historically been underrepresented in the Vis Moot and also in the broader international arbitration community, and that is something we are seeking to change. It has previously been the case that 1% of the 400 teams, less than 1% of the 400 teams participating in the Vis Moot has come from Sub-Saharan Africa. You can see the strides we've made in the past 5 years by clicking on our season report, 2024-2025 season report, which is on our website, and also on our social media platforms. In 2025 and 2026, we'll be working with 15 jurisdictions across the continent. And you can be part of this journey and of this story by attending the pre-moot in Nairobi. This is from 17th to 21st of February. So if you're able to join in your professional capacity, please do. But you can also support us by partnering with us. And if you're interested in doing either of these, please reach out to us through our email account or through our social. And we will also be having upcoming education series. I think they are on a slide that will be shared shortly. Can have the slide shared shortly, please. Thank you. So on 19th of November, we will have a session, which is literally on Wednesday, about the intersection of the SIAC rules and the moot problem. And the next one will be on November 22nd on the legal writing workshop. This is open only to AI Africa and the Moot teams. And then, but please feel free to join the 24th in conversation with a moot master, and importantly also on 26th of November, exemptions under the CISG. So it's going to be a very fun-filled month as you engage with the topics in the moot problem, and also as we support you, and we look forward to seeing you in the next education series. Thank you very much.
Thank you very much.